Hi, and welcome to Stencil TV. You're here today with me, Mulibi Mapayane, the COO of Stencil Technologies. I'm joined by my partner and co-host, CEO of Stencil Technologies, Ohone Mutwahai. We're joined today by Senwelo Modise, the partner and head of technology and media and telecommunications for Bothlole Law Group. Today we're talking about the Data Privacy Act.
In my reading
Yes.
on this thing, from a technology perspective, I see what a lot of the guys in our space do.
Yes.
So they will take legal eagles like you guys and then hide behind what was that thing you called that Facebook uses? So you hide behind
Legitimate interest.
legitimate interest, right? So how many times you get into a website and it just pops out a thing? Do you want us to track your
sure.
activity with cookies, right?
Yeah.
And the consent is actually where the challenge with the data protection compliance is going to lie, because it talks a lot about the focus on consent. It's so easily manipulatable against legitimate interest that it allows you to literally force people into consent. So a cookie comes up, you want to go into your banking site. Do you want us to track your activity and potentially share it to third parties? Or by the way, if you also want, you can read more. And read more is like another 20,000 pages.
Yeah.
Who wants to? So then you have a button that says, yes, I do.
Yeah.
And
that's it.
And then read more. That's it.
Yes, I do, and read more.
Yeah.
And you can't even say no.
Yeah.
But that's consent.
Yeah.
Right? The other example is, I use an iPhone and you get, request for update. Do you want to update your software?
Yeah.
You want to update your software. After
And
a while,
terms of
you give in,
Yeah.
and then you are, it says these are the terms of use. Then you scroll,
Yeah.
and then it says agree. Right?
Yeah.
Yeah. And then you say agree.
Yeah.
The agree which says we will use your credit card data. We will do this. A few apps, these 300 apps will track your activity. Da, 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 da.
Yes.
But you're not going to go through the 36,000 word
Yeah.
terms and conditions. And they know that, and they bank on that.
Yeah.
And then you say yes, because the alternative to that is your phone turns into a brick. They're going to switch it off tonight.
Yeah. And that is
Now, would you call that consent? I mean, I've invested in this 20,000 Pula device,
20,000 people.
and I mean,
Right.
they're a little more expensive than that's Senwelo.
What an expensive
Well,
brand.
you know what I mean, right? Okay, so
They get a little more expensive than that. That's Senwelo.
Okay.
So, I mean, then the alternative to that is this thing's going to turn into a brick.
Yeah.
Okay. Yeah.
Would you call that consent?
You got 100 fit in your pocket, huh? Sorry.
you see what I'm
I
saying?
get the concern, but I'll draw back to personal data, defining. If you think of cookies, is the data relating to cookies personal? More often than not, cookies don't deal with personal data. And where cookie law comes in, which is also why you ought to carry out assessments to see whether you need to do it or not.
Yeah.
Cookies are a thing of the EU Privacy Directive. It's a law that actually promulgates that if you have a website, whether the data is personal or not, have a cookie banner,
Yes.
which people need to agree to or not.
Which is not really.
Yes,
Yeah.
so for us, this side of the equator, our law deals with personal data. If cookies do not identify anything personal, then you...
But like
You know,
like we were saying earlier on, you can the data that cookies collect, you can reassemble
If
it
you can,
to get to
if
an
you
individual.
know you can, then you ought to do what is right.
Yeah.
Then let's get to the consent. If you look at
No, but so the point I'm making is the tools are there to do that.
do it.
So the law needs to cover that.
the law already covers it.
Okay.
Yes, the law already
Oh, I thought you
covers
said
it.
the law
question,
doesn't.
No,
Okay.
the law. I'm saying the law is different for the EU.
Yeah.
There's an e-privacy directive. It doesn't matter whether cookies would be identifying or not identifying.
Right.
For our law, the law is such that the cookies must identify the person. If they identify the person, that's when you'd be subject to the Data Protection Act. So if you know, as the data controller, that there's going to be identification, comply with the law. Because you trying to
Even
run away
identification
from
by
yes,
extension.
yes, yes.
Yeah.
For you trying to run away, you'll have a difficult time having to answer, because accountability is a big part
Gotcha.
of compliance.
Gotcha.
You're going to have a hard time accounting. Why
Yep,
did you
gotcha.
not do the right thing in relation to this? But with consent, the critical thing is that it must be freely given and it must be informed. So if it can be freely given but not informed, then it's going to be a problem. And by informed,
please explain both.
Informed, we mean you have to have sufficiently informed me about what you're doing. So if you have a privacy notice,
Yeah.
if you do not have a privacy notice, then it means you didn't inform. If you have a privacy notice that is complex, you didn't inform.
If your information is a 36,000 word document, is that informing?
If
That
at all,
you know
if
I'm
at
not
all,
going to read.
if at all you know that, say you are focusing, you are offering your service to mobile money,
Yeah.
and you know that the demographic
Yeah.
you are focusing on is, say, not too literate.
Yes.
You have to
Yeah.
make sure that they can be informed. If they are not
Ah.
informed, they didn't
So it's
consent.
gotta be demography
Consent
appropriate.
must be
Even-
followed by
yeah.
consent that is freely
That is
given
appropriate.
and informed.
Yeah.
So if at all I go on your site and you have explained so much about security, you have put in 100% staff, but that doesn't communicate to me.
Yeah.
And also here's another thing. Communicate only that which is necessary. Most privacy notices have things that are not necessary.
Okay.
If you look at the Act, it wants the habitual residence of the data controller. It needs you to specify what purpose are you collecting data for, what data are you collecting. It wants you to specify what rights does someone have, can they exercise them. Those are the three critical things, and then the others are optional.
Okay.
The others, like, okay, you see, if you tell me that you have implemented security safeguards, what do I do with that? It's yours. What I need to know to be able to make a decision is what data you are collecting, what you are collecting it for, what rights I have. The right to access, the right to rectification, the right to deletion, and how do I exercise it? So give
Those
me
rights.
the contact.
Yeah.
Yeah, so you'd find that most notices, even if you have your commitment to security, if you don't have the contact I can get in touch with to exercise my rights, you're violating the Act.
Yeah.
Yes.
So, I mean, that is critical. I think
That's
that's the
very critical.
most important thing that we can take away from this discussion.
Yes.
Is that, one, you need to inform people clearly and concisely.
Yes.
Two, you need to tell them why you're doing and what data you have and why you have it. And three, you give someone the opportunity to rectify, to either ask you to delete that data or to ask you not to process it. And that's really a simple way to understand this Act, if you think about it. As long as you're governed by those three principles, you're okay. You're in the clear. That's what you say. Everything else is optional. You said, I like optional.
No, I would say for as long as you give effect to all data protection principles, you're okay.
Yeah.
And by data protection principles, like I said, it's one, lawful and fairness. And by lawful and fairness, we mean you have chosen the right legal basis.
Right.
We have purpose specification. You have specified what you are going to do it for. And if you look at the Act, it's saying it must be explicitly stated.
Okay.
So explicitly stated means it must be documented.
Right
It
there.
must be and it must be communicated.
Yeah.
And then you have purpose limitation. Purpose limitation, we mean only use it for that
the
which you
purposes
said
that-
you would use it
Yeah,
for.
yeah.
If you want to do it for something else, then the Act says either get consent or you have to do it under written law. Yes. And you have to take into consideration necessity and proportionality. Necessity and proportionality is whether the data you have collected is adequate and relevant. If you collect anything irrelevant, you didn't cut it.
You're not doing it right.
And there also is where the violation is going to come out from, because most people collect irrelevant
becomes-
data
yeah.
for the
It
purpose
becomes
you are
very-
trying to, yes. And then you also have retention limitation. Only
Tell me
store
about this. Yeah.
retention limitation. The principle really is store data for the period that you need it for.
Okay.
Where the principle derives is that if you are left alone to store as much as for as long as you want, you're probably going to ignore that server.
Yeah.
And you are not going to patch it, you're not going to put the updates, and it will be exposed.
Okay.
So only store it for the period you are required.
Okay.
The period will be decided by the category of data that you have.
Yeah.
So that's why that process is very important of defining. This is you have to do an
This is what I
inventory
use the data
of
for.
data, the
Yeah.
data mapping. So if you have data for tax, look at the Income Tax Act. What does it say about retaining?
Yeah.
Look at the Companies Act. What does it say about retaining? Look at all the acts that you ought to comply with from a
Right.
regulatory perspective. What are the periods? After you look at the laws, then now go to if at all I'm not obliged by any law to keep this data for this long, what am I justifying the retention for?
Yeah.
Am I still offering the service? If I'm still offering the service, then it means I need to keep it. Am I still looking to give you some marketing material, then I can keep it. If at all you aren't able to justify the retention in law or from a purpose perspective, then do not keep it.
Where is the line in terms of provision of a service that is only provided on condition of acceptance of consent? Is that a murky line? Because
where you're forcing someone
so you're only going
to get your service.
You're only going to play, Candy Crush.
Yeah.
If you accept this thing. If you don't accept it, stay away from Candy Crush. Is that so? And I think we also do the same. So we have the terms and conditions for our platform, and those are the terms and conditions. And they protect us. Yeah. So if you say you don't want to be held accountable for the messages that you send to 50,000 people, and you want that liability to lie on us, we're not going to take it.
No way.
So we block you out of the platform. Is that where's the line there? What does the law say about that? If I say you can only use it on condition that?
The consent, where consent can be used is where someone would not be denied the service. I would give you an example.
Okay.
We usually can't use consent for employment because it's such that if I don't consent, then I don't get paid.
Yes.
If you don't get fully vaccinated.
If you don't get, yes.
Yeah.
So I can't say for sure, but I would have to sit down and see what it is, why you are crafting that term that way, and why the services. Of course, some services don't really need to apply to the Data Protection Act. You see, you are talking about liability.
Yes.
When you talk about liability and you're talking about SMSs, we have to also consider the Electronic Communications and Transactions Act.
Oh, it brings that in.
Which has limitation of liability on mere conduit,
on its own,
on catching,
yeah,
on hosting.
Yeah.
You get it. So it may not be the Data Protection Act itself.
Yeah.
It may be a limitation of liability that derives from somewhere else. You need to sit down and review that. But one of the things that sometimes companies do is block out people when they don't need to block them out.
Okay.
You can use other legal bases like legitimate interest. Then you can just let someone go through what they have to go through, and you have the appropriate legal basis for processing their personal data. So consent is not really the only thing. And I know for most people they think the data protection means consent. No, data protection means processing personal data in compliance with the law.
And it's just about documenting it.
You document, have the right processes, procedures, and policies.
So that's the whole point I'm making.
That's the whole point.
So if you set the right processes and
and you can answer, you can be
the analysis, and you're accountable. But then here comes a guy, he wants to play Minecraft.
Yes.
But he's not allowing me to use the processes that I've built.
Yes.
Behind Minecraft that keep me compliant. You are letting me in or not?
Yes, but now that's a relationship between data controller and processor. It's not really the people.
Yeah.
It's data processor and controller. So both of you need to consider your obligations and see how you could meet each other. And if you can't meet each other, then the relationship may not work.
Because he's the controller, your Minecraft person in this.
Yeah.
But you also may be a joint controllers, because that's another thing. You see, a controller is just someone who or makes a decision as to what the purpose and
that's who's accountable, right?
Yes.
Yeah.
No, even the processor is accountable.
Oh.
Everyone is accountable. The only person who's not accountable is the recipient. So yes, in the act there is a recipient.
Who's the recipient now?
Recipient is like your employee. Like when someone is here at Stencil, right?
They're CC'd in an email.
In an email, yeah.
Okay.
Employees are recipients. They are not really processors. Even if they see personal data and they do stuff with it.
Okay.
Your recipients may also be the regulator you are giving information to, reporting suspicious transactions. So recipient is really someone who receives personal data or who data is disclosed to, but they have no obligation to comply in relation to that data that is disclosed. They may have an obligation to comply in relation to everything else, but not in relation to the data that is disclosed. So see, that's why it's important you have to have an overarching data protection policy that will define who do you need to disclose to, who are your recipients. And that's also another thing, you may need to inform the data subject, who are your recipients. Yes.
So that's it.
So
Interesting.
you have to take into consideration who the recipient is. But both data processors and data controllers have obligations. Like, for example, when there's a breach, the data processor has to notify the controller. It's the
Yes.
controller that notifies the commissioner.
Okay.
So if you have you'd realize that in your service level agreements or in your dedicated agreements for data protection processing, you need to set those out. That this, if you want to use my platform, this is this is what you need to do, and it's this way because I need to comply with the law.
Right.
You should not be forced into non-compliance. Yes.
True.
For yourself, right? Because we've got a business interest.
Exactly.
Yes. And
There's
you
a commercial
pay the
interest
fines,
on
you pay the fines.
Yeah. Exactly.
You don't
And
comply.
they're not small. Like, what are we looking at in terms of some of these fines?
In terms of the fines, the uppermost fine would be processing personal data in sensitive personal data in contravention with the Act, and that is a fine of up to 1 million bula or imprisonment term for 12 years.
That's not bad. 12 years? You have to do that stretch.
Yeah,
but who's going to jail? The entire value chain. I'm just trying to see
not
if
the decision makers.
I'm just trying to see if
The
Mulivi can
decision
be
makers.
the.
Boss,
Yeah.
you're on your
Is
own.
he in charge of data?
He's the controller.
You're the controller.
I'm just the guy that sits there.
No, the controller is the company itself. It's never
Yeah.
going to be an employee. And no, it's not the individual.
But then who was the directors?
It's the person who makes
liable
the
there?
decision.
Yeah.
So decision makers in companies, there's directors. If it's big companies, there's board chair or anyone in the board. Yeah, the directors pretty much, there's your chief information officer, chief executive. But really, the one who, when we assess who is responsible for data governance, who is responsible for information, that person.
But you know what? Funny that actually that is so. It's actually quite minute compared to the fines you get in the EU, and I'm sure I've read quite deeply into GDPR.
Yeah.
I think it's something like 4 million euros, or 20% of your global revenue.
Wow.
Whichever is higher.
Wow. 20%.
So you imagine 20% of Facebook.
Sure.
Yeah. So it's actually
Global.
It's actually
of the global business.
It's actually the other way around. It's
what is it?
4% of your total
4%, yes.
turnover,
Yeah.
or total annual turnover, or 20 million.
There you go, that's the one, yes.
or 20 million. But that's for
But
sensitive personal data.
Think about 4% of Google.
Boss, that's a lot
That's
of money.
money.
Yeah, but so far there's been hefty fines, and like I say, the thing with data protection compliance is that generally people will be slow to engage experts. They'll be slow to engage someone outside because they truly think that whatever systems they have for information security would be sufficient. But most of the violation is not going to come from organizational or technical safeguards. Well, technical safeguards, you probably will have them in place. You would have segmented your network, you would have access control.
Yeah.
They're going to come out of the soft parts.
Yes.
Then do you have the appropriate legal basis? Did you inform?
It's the actual implementation.
Did you carry out the impact assessment? Did you appoint the data protection representative?
So what is the experience of the data protection officer that you speak of? Is it a legal mind or a technical mind?
It's someone with requisite qualifications.
HR?
What a legal answer.
That's a legal thing to say.
But honestly, it's someone who can understand it. That's it.
It's someone who, if the question is in the affirmative if the answer is in the affirmative when you ask,
Yeah.
can you oversee compliance? Then you may have requisite qualifications.
How many, you can be a compliance
But yeah,
officer. You can
who
study
can be in risk and compliance? It could be your
I
legal.
see,
But
I
with data protection, you really ought to understand it because in its nature, it's technical. Consent is not the consent that you are used to, and you may think people have consent, but you didn't cover the information basis. Right? You may think that you have sorted out your organizational safeguards, but you don't have something as simple as principles of least privilege.
Right.
That only these people will see
Principles
the
of privilege.
least privilege in information security.
Okay.
That you would limit.
Yes.
Privileges. So really, it requires you to re-look into your policies because it may be as simple as the fact that you didn't disclose a data breach. You thought it was simple and you didn't disclose it, and it comes at a later stage to bite. So you have to re-look into whether you have the proper processes, whether you have the proper procedures, and the policies that will help you achieve compliance and accountability.
So is this something really that organizations should be doing on a yearly basis? Like just a quick review of their processes and so on and so forth?
They should do it on a daily basis. Yeah, if you do it on a yearly basis, you may find that you are lapsing. But whatever you set up a framework, that framework will ensure that you have identified what you have to do. Okay. I like to refer to the GDPR because you find that many organizations would say they have to comply with the GDPR, or you go on their website and you find the privacy notice making reference to the GDPR. But the question would be, does like the territorial, like you guys, which is why now I need to start charging for giving you legal advice. But the question you'd ask is, does the territorial scope of the GDPR fall within your? Are you underneath it? Are you? And it's a nice thing to say you are compliant with the GDPR, but it's a double-edged sword in the sense that it easily tells how much you are lacking from a data protection perspective. From this perspective, if you have to comply with the GDPR, do you have a representative in the EU? Because you have to, in terms of the regulation, you have to have someone who is going to interact with the regulators. You look at the privacy notice, it doesn't say anything about rights, but but the regulation is saying do something about rights.
So the purview of the GDPR enforces you to comply to it as long as any of the data that you collect, any of your subjects, is is a citizen of the EU or from the EU territory.
So that's where
that's
where the conundrum is.
Yeah.
It's people within the EU, so it's not citizens.
Yeah. So if I access the website from an EU nation.
No, not even.
I don't even have to be a citizen.
That's why I say many organizations think they are covered by the GDPR, but it's far away from it. So the GDPR has this thing we call the target criterion.
Okay.
So the target criterion would be that yes, people are within the EU. It's a twofold test. People are within the EU, well and good. Within the EU, we don't really need you to be a permanent resident, but you are within the EU.
Yeah.
The second one is the processing activities that you do. In those processing activities, you are offering goods and services to people in the EU. Yes. By offering goods and services is not as simple as someone accessing the site. It's actually need to be deliberate that Stencil Technologies is targeting people in the EU. You may even have an .eu domain. You may even have. You really need to target. Like I want a market. It needs to be deliberate. It shouldn't be the fact that I have a website and I have an inquiry from someone in the EU. No, that's not enough.
Yeah.
Now let me ask this question. What if it's a company that's incorporated in the EU?
Yeah, but what?
Oh no, that one is obvious.
It's obvious.
You're in there.
Yeah, in
so,
there.
Yeah, there we
are.
Yeah, you're in there.
Ideally,
so we are in trouble.
So you are incorporated in the EU.
No, not us incorporated, but our clients incorporated.
No. But if you have clients incorporated in the EU, but in your solutions, do you target people in the EU? Are you trying to get that market?
I mean, market's a market, right?
Yeah. Or if at all you have clients incorporated in the EU, and you are processing data of their representative, you still need to consider though whether really you ought to comply, because the issue is it's whether you are offering goods and services, whether for payment or for non-payment. But you need to have an assessment first. It's not a decision you just take from.
So what I do know is that we certainly do have clients that actually reside in the EU.
Yes.
Whether as incorporated organizations or as individuals.
Yes.
So for instance, even through our payment gateways, we will have people using like EU MasterCards and cards, that sort of thing from EU banks, right? So already there we are starting to get into that territory.
Yes.
Well, that's Stencil TV for you today. Thank you for joining us, and we will see you next time.